Welcome to This Week in Legal Blogging for December 10th, 2020, in which we talk with leading bloggers from across the legal industry. My name is Bob Ambrogi. I write the blog Law Sites and have the podcast Law Next, both focused on tech and innovation in law. This program is presented by LexBlog, providing lawyers with turnkey digital publishing solutions and strategic consulting for 16 years. Find out all about it at lexblog.com/products. And all of our interviews, I've got a couple of dozen of them now with leading bloggers, are available on YouTube at youtube.com/lexblog. We are also available as a podcast at Apple Podcasts or Spotify or wherever you listen to podcasts. And today I'm very happy to have as our guest Rebecca Tushnet, who is the inaugural Frank Stanton Professor of the First Amendment at Harvard Law School and a director of the Berkman Klein Center for Internet and Society. That's all well and good, but she's here today with us because she writes a blog. She writes the blog, the 43 blog, or 43 paren B. Good to see you. And as I said before we actually started recording, I wasn't sure whether to call it it's 43 paren B log, which I assume is a reference to the Lanham Act. Is that where we get the 43? Or
yes, and in fact, geekily, right, it really should be 43A1B, but nobody
Right.
wants that. So I figured that 43B would be close enough.
Yeah, and I was just thinking, wait, 43B isn't exactly the right reference, is it? But
Yeah.
okay, that's geekily. But anyway, so before we talk about your blog, why don't you just tell us a little bit about yourself, what your focus is, and what you teach at Harvard?
So I specialize in intellectual property. So I have been doing that throughout my career. I've moved through a couple of law schools, but now I teach trademark, advertising law, and copyright law with occasional first-year property law. And I blog about trademark, copyright, and false advertising with a special focus on false advertising because there isn't as much out there for false advertising, especially for a sort of comprehensive approach that deals with both consumer protection and competitor versus competitor actions. So I've always been very interested in the latter and also interested in integrating the law of consumer protection actions versus competitor actions, because courts often treat those differently, even though the basic idea is pretty much the same.
Mm-hmm. And Yet interestingly, one of the notes on your bio at Harvard is that you are also an expert on the law of engagement rings. Can you explain that?
Yeah. So this just comes out of my student note, actually, which was about what happens to the engagement ring after the engagement is broken before marriage. And what I discovered was, perhaps not surprisingly, there's this big history of sexism behind the almost universal U.S. rule that the guy always gets it back no matter what he did or no matter why the engagement was broken, even though you cannot recover for basically the lost costs of setting up the wedding, even though they are traditionally borne by the bride side of the family. So the losses basically fall very disproportionately. And my note was about that. There is no personal story about it, but I do like it as a topic because everyone, lawyer or not, has very strong intuitions about it, and it's a really useful way of getting into thinking about what law is good at doing, right? And why you might attribute fault in ordinary life, but not be willing to attribute fault and not willing to have the courts judge matters of fault.
Yeah, that's really interesting. I bet I don't know if that's online anywhere, but if it is, I'm sure it's got real Google juice going for it and probably gets lots of hits on it. You're also known for your scholarship and your work around fan fiction issues and copyright and fan fiction issues. How did you get interested in that?
So I've actually been a science fiction and fantasy fan all my life. As a friend of mine says, I invented fan fiction in my room. I made it up. I discovered it myself. And it turns out other people were doing it too. And I had known about these fan practices, fan art, fan fiction, which used to be distributed physically as really their only means of distribution, but jumped online basically as soon as it was technically possible to do so. And when I was in law school, I rediscovered these things, and I was in law school, so I started asking, well, is this legal? And I actually never really looked back. I fell in love with intellectual property and switched my focus, and everything I did sprang from there. And I was fortunate enough to be involved with the founding of a nonprofit, the Organization for Transformative Works, whose mission is to preserve and protect fan culture, non-commercial fan cultures. And so I'm still pretty involved in that.
Yeah, and how have we been doing on that front? I mean, how evolved is the law around protecting fan fiction, or how onerous is the law around fan fiction?
So the good news is there's basically a big cultural shift, and copyright owners now understand that it's neither a good idea nor something that they have a high chance of prevailing on to challenge fan works, non-commercial fan works, legally. And the Copyright Office has actually found that fan videos, at least fan videos that we've showed them, are likely to be found to be fair use as part of the 1201 exemption proceedings for the technical anti-circumvention law. That's sort of a para-copyright law where the Copyright Office has some authority to do some rulemaking. And so while there's very limited precedent, I think the limited precedent is basically a sign of success, that people are not, that it's so obvious that you shouldn't sue over this, and I think that's important, because there was, especially when the internet got going kind of commercially, there was a lot of uncertainty about exactly what would go on.
Yep. So you have been writing your blog for a long time. You've been writing your blog since September 2003, you're even still publishing it on Blogspot, which tells you it's been around for a while, because everybody published on Blogspot back then, but it's rare to find people publishing on that now. But I'm wondering, how do you get started with blogging? What were you doing at that point in your career, and what interested you about that medium?
So if I can even remember that far back,
you can,
which isn't clear. Obviously, my subject matter is really aligned with new technologies. A lot of the interesting legal issues that involve new technologies, and so I heard about blogging and decided, well, I'll just try this thing out. I didn't really get rolling until 2 years later, in 2005. And what happened was my son was born, and I started to have these chunks of time where I could work, where it was not really conceivable to do 8 hours of work straight, but it was perfectly conceivable to do 40 minutes of work. And relatedly, I'm very interested in promoting the idea of advertising law as something that people should routinely study. Advertising law covers basically everyone. Even if you're a nonprofit, advertising law is going to govern some of the stuff that you do. And every law school in the country teaches securities law, but not every law school in the country teaches advertising law. I think this is a total mistake. So there's a huge demand for it, right? There's a lot of regulation. There's all sorts of potential actors involved. So, there's consumer lawsuits, there's your competitors, there's government regulators. There's not just basic truthfulness, but there's all sorts of intellectual property and other things that you need to know to do advertising right. So I stepped up the blog as an idea that I would cover recent developments, right? Recently decided cases that I found interesting, and kind of try and build up some public discussion on advertising law. And so I started doing that, and blogging the new cases that I found. And I found I really liked it. And I also found that it was extraordinarily helpful for when both giving me ideas for what I should write about next. And also when I started to write, I would usually have started articulating my thoughts with respect to, a recent case. And I could pick up on that and figure out, okay, is there a larger thing here? And what do I want to say about it?
Yeah. Were you already teaching at that point, or were you still?
Yes. I was at NYU at that point.
NYU, and then you went to Georgetown, and then you went to Harvard, right? Is that?
Yep.
Yeah. So did you, at that point, have any debate in your own mind as to whether, you should spend time blogging or spend time in more sort of traditional academic forms of publishing, or how did you weigh that equation?
So that's a great question. And I do remember at the time there was some angst about whether we should, as legal academics, should this count? Will this count? And I have to admit, I was in a fairly privileged position where, I was publishing. I was also publishing a fair amount of traditional scholarship, and doing what I thought was good work there. So to me, it was additional. I wouldn't probably ever tell anyone to blog instead of publishing traditional scholarship, although there are a couple of people for whom it really worked, like unquestionably so. But, it kind of wasn't the way to bet. And things have changed, I think, with Twitter becoming such a dominant medium for academics. But I do think it's a way to be, at least in part, a public intellectual. So I was always prepared to defend it on the merits. That being said, I don't think I neglected my traditional scholarship to do it.
Yeah, I mean, there has been this, there's been talk over a couple, probably more recently, a lot more recently than from when you started blogging, but this idea that, the sort of the traditional law review is an anachronism whose time is long past, and that blogging is perhaps a superior form even of academic or scholarly publishing. What do you think about that?
So I guess I think both the positions are pretty reductive, right? So my question is it good work? And if the work is good, then I want to read it in a law review, and I want to read it in a blog post. And also there are just different things, different links. So there are kinds of arguments that are simply not fit for a blog post because they're long and they're involved, and that's fine. And in fact, when I do an amicus brief, I post the amicus brief, and I usually don't even really do much to summarize it, because usually there's actually an argument that's longer than you would want to fit in a blog post. So I think having an academic community that has people in it who do outreach to working lawyers and to the general public is really important. It is not particularly important that any one person do any of these things. And so I'm never going to tell anyone this is how you should, connect to the public.
Mm-hmm. So if you kind of started more seriously, 15 years ago with a regular routine of it. How has that routine remained the same or changed over the years? So
I think I've tried to sort of keep the focus as much as possible on the stuff that I know other people aren't going to cover. Although actually that's changed too. So there's much more coverage of advertising law than there was when I started out. So that's
yeah, there are other blogs, certainly other blogs out there covering it, but more from a corporate point of view, I think.
Right. So one thing that I hope I never change is, I'm going to tell you what I think. There's going to be commentary in here about things that I think are particularly well-reasoned or perhaps particularly badly reasoned. I have, I'm not super consistent about this, but I am trying to keep an eye about not putting the full name of someone who's sort of dragged into something. So, with the visibility that you have, I probably am mostly just going to use a last name unless it's really important to know exactly what's going on. I understand why if you're just sort of accidentally in a case. I also started blogging the conferences I attended. Unfortunately, that has not happened very much in the past year, but hopefully we'll be back to that soon. And I enjoy that, but I'm also trying to be mindful of the difference between sort of stuff that's presented in a limited group of people versus stuff that you're presenting to a community.
Yeah. How does the blogging relate to your teaching and other scholarship? You're following cases on your blog. I assume that must play into all the other work that you're doing.
Yeah. So it does keep me up to date, which is very important, and it means that when, for example, Eric Goldman and I have a casebook on advertising law,
right.
And
published online.
Right? Moderately priced, if I do say so myself. I mean, it's $15, so I actually think that is a fair price for the work.
That's a deal.
Yeah. When I go to update it, right, I have a really ready access to what's new and whether it's significant. And most of the time, I won't put a new case in, but if a new case is interesting, and especially if it sort of teaches something, in a different way than what's gone before, I might well swap it in. And likewise, I think, as I mentioned, if I've been tracking a development for a while, if I go back and I look, I've written something, sometimes I'll find, I've said the same thing 4 times for these 4 different cases. Maybe it's time to look for an amicus opportunity or to write something.
So we talked about the career implications of scholarly writing for an academic such as yourself. What do you think has been the impact on your career of having it blog? Has it been neutral or positive or negative?
So probably positive. I have never been, let's put it nicely, I've never been particularly socially sensitive. And so I just write down pretty much what I think. I'm sure that has also hampered me in some ways, but overall, it's been a real positive. And fortunately, as an academic, the norms of scholarly freedom do let me say what I think. I only work with the clients that I really believe in, and so I get to stick with my commitments, and that's been good. So I think I would say 2 things. I think constantly writing is actually really good for you as a scholar. It keeps you limber, and so doing that it just sort of keeps me in practice. And then being exactly who I am has been liberating and accustomed me to trying to figure out what I really think and trying to be honest if my views change. Sometimes they do, right? Sometimes the matter no longer appears to me as it appears to have appeared to me then, as Justice Souter would say.
Yeah, we do grow and evolve. Have there been times when those opinions that you've expressed on your blog have caused a reaction or a backlash that surprised you?
I mean, so I should say, like, it's not at all clear to me that I would hear people complaining about it for various reasons. I suppose the one thing that surprised me kind of early on was I had actually written an article about the gender implications of various fair use decisions. And when I blogged about it, I got a little bit of backlash, like, you shouldn't say that fair use shows gender bias, because fair use is under attack and we need to preserve it. And my position was always, fair use is really important and we need to preserve and strengthen it. And one way we can strengthen it is by making it equitable. But that was really relatively tiny. Mm-hmm. The other kind of funny thing that happened, prefiguring stuff that is actually much more significant today, is when I first started out. So Palm Wonderful is a very interesting company and quite litigious. And sometimes I think their lawsuits are good, and sometimes I think their lawsuits are bad. But I was blogging about one of their early lawsuits, and their social media people reached out and wanted to give me a free case of Palm Wonderful because this was sort of early influencer marketing. And right. I want to be super clear: they did not ask for anything. Right. Right. They were not trying to influence me in any way. But I'd never heard of such a thing. This was years before Instagram. This was in 2007 maybe, and I sort of, it set me back, and I thought about it, and I thought, no, I'm going to say no, because I'm just worried about accepting this. But that was probably the most surprising thing.
That's funny. You actually just wrote recently about an influencer payments case involving a vibrator, a vibrator manufacturer and the owner of a sex boutique who was apparently an Instagram influencer. That's actually very relevant to blogs, because I think a lot of bloggers probably aren't really aware of the rules around what they can and cannot do, or should not do, I guess, with regard to that. I mean, the companies themselves have obligations, but those who right. are posting the content have obligations, right? Can you kind of summarize what those obligations are?
Yeah, so they are, as you mentioned, much more heavily on the advertiser. So for basically agency purposes, the speech that the blogger makes on behalf of the company as a paid agent for the company is going to be attributed to the company. So if the blogger makes statements that the advertiser couldn't substantiate, factual statements, then the advertiser could get in trouble. The other part of this is disclosure. The FTC and, in fact, regulators worldwide think that there should be disclosure of a relationship when the existence of the relationship would be material to consumers, which the regulators think, and I think they're right about this, happens in a lot of circumstances. Even when you're just offering pure opinions, people still want to know if you're being paid to say, oh, I think this is super cute. And to my knowledge, this isn't a huge problem for legal bloggers, but it's definitely a topic of huge regulatory interest and activism. And every day I get a new alert about some regulator somewhere in the world who has put out influencer-specific guidelines. Even though these are super standard, advertising law principles, we just have a new situation. And not for nothing, a whole bunch of people who are suddenly subject to this old regulation just because the technology has changed in terms of distributing messages.
Right. Well, probably not all that applicable to legal bloggers, but had you taken that case of Palm Wonderful and then were subsequently writing about Palm Wonderful, would you need to disclose that in some way, or only if there were a commercial?
So, I think this is a fascinating question. So because they didn't ask for anything, so I think the answer is, if I were blogging about the Palm Wonderful product, I think yes, I would definitely have to disclose that I got it for free. To the extent that I just blogged about a new Palm Wonderful case, I don't think so, because there were no conditions, and we didn't have an ongoing relationship. But I feel like yes, it would be a good idea. Right.
Yeah.
And sometimes it's a good idea to disclose even more limited connections. I tend to try and say if, for example, I've actually used a product, right, that just happens to be involved, even though I don't get sent products or anything like that. But
Yep. Yeah, we're not going to find you on Instagram endorsing products anytime soon.
No.
No. It seems to me from reviewing your blog that you are quite regular and prolific about posting to your blog. Do you have a routine around it? How do you keep up with it all?
I have a Westclip search for false advertising, and every day I go through it, and I discard most of the cases. So I try to limit this to where there's at least one reasonably interesting point of law, or one where there's like a split of authority, and then I'm just going to sort of add to the public record of the cases. And I know I can be super wordy, so I'm making a little bit of an effort to summarize more, but I know it's not great because I actually love all the details. Like, one of the things that I love most about advertising law is that to do it well, you have to know the client's business. Right. And understand what matters to the consumers, and understand the context of the purchasing decision. And I just love that the law and the facts are so completely intertwined. So I always like the weird little details of a case.
But so you're looking for some element of uniqueness or something that makes the case stand out from
right.
Those that are more routine, perhaps.
Right. And then, I also blog the copyright and trademark issues, again, trying to do basically the same principle, and certainly much more spottily. But because these are often alleged in the same case, I end up with a fair number of them.
Yeah. Are you, do you blog about your own work at all? I mean, I know, again, we were talking before we started recording about the fact that you've been involved in the Senate's review this year of the Digital Millennium Copyright Act, which is 22 years old, I think, this year. And there's kind of a look at whether there needs to be changes, and you've testified and spoken on that. Is that something you blog about as well?
So this is another one of those things. So I try and post links to my testimony to it. Often it's just going to be longer than I think a blog post should be, but I'm just going to put up a PDF, right? And probably not say too much more about it.
Yeah. Is there a nutshell version of your testimony on that this year? I mean, where do you stand on DMCA reform?
So the nutshell version is, this is one of these things where, like democracy, it's pretty much the worst thing, except for all the other things that have been tried. So I don't think that Section 512, which is the safe harbor provisions for internet service providers, is in need of reform. And I think that a lot of the things being floated for this are actually what the people who are proposing them really want is to hurt Google and Facebook. And frankly, I understand that impulse, and I'm not entirely opposed to it. In fact, maybe I'm in support of it. But the problem is, with doing this through copyright reform, is that Google and Facebook are going to survive anything that you throw at them. And what you will do by changing copyright law instead of working with antitrust law is ensure that nobody else will ever be able to challenge Google and Facebook. So I think the safe harbors are actually super important for challengers, small market entrants, and The stuff that we hear about, the massive online infringement problem, like, it's just got the wrong target. Yes, there are pirate sites. They're already violating the DMCA. They can already be shut down. And like making them super duper illegal, like double plus illegal, when they're already illegal, is not actually going to do anything. Google and Facebook are already implementing strong screening mechanisms. And although content owners have disputes about that, about how good they are, passing a law won't make them technically better.
Right. So it's the smaller companies that are going to get hurt by.
Yes, right. So, it's a big set of issues, but I'm actually heartened by the antitrust complaints that we've seen, because those seem to me to be targeting the right aspects of behavior rather than trying to mess with copyright law to do so.
Yeah. On your blog, do you have a thought in your mind about who your readers are, who your audience is, whether you actually know it or not? Who do you think you're writing for?
That is a great question, and I occasionally think about it because at this point, I think I am mostly writing for a lawyer who already has some basic knowledge. It depends on the area, but often, I don't want to tell you about the basics of the idea expression distinction, or I'm going to assume that the reasonable person standard. Although sometimes that's important just to give a good summary of like what the court is doing, to the extent that it's relying on a particular conception of the reasonable consumer. But I do use a fair number of concepts without, backing up and explaining them. And I think at this point I'm comfortable with that. Right. But
so you're not writing down to an audience necessarily. You're writing to an audience that has some degree of knowledge, maybe even sophistication around this area.
Exactly.
Yeah. And do you get feedback at all from readers, or are you engaging with readers in any way whatsoever, or even on Twitter or anything? Or
every once in a while, which is great. I always love hearing it, and I'm perfectly happy if someone just skims the headlines and reads the occasional one that seems relevant to their interests. That's great. It's wonderful. I would say most of the feedback I get comes from people sending me stuff, saying this looks like it's one of yours.
You ought to write about this, or
yes.
Yeah, good. You're somewhat unique in the topic that you write about. But do you think do you have any sort of general lessons or advice about blogging that you think you've learned about how to be successful at blogging, how to make a go of it?
So I would say, if you have an internal motivation, that's the best reason to do it. So I'm not saying that I would definitely still be doing it if I knew for sure that no one would be reading. Like, there's definitely some external motivation, but for me, it has proven so useful in helping me sort of stay flexible, stay updated, and also sort of start thinking through things and watch them percolate and develop into something that might be a larger project. That I'm going to keep doing it as long as I continue to get those benefits. And to the extent that anyone else finds it useful, that's wonderful. And I love to hear it. But if you're just doing it for recognition, that's probably not going to be enough.
Right. So for you, it fits within everything else you're doing and helps fuel whatever everything else you're doing. It sounds like so.
Exactly.
Yeah. Good. Well, any final words of wisdom before we wrap up here today?
I actually think that having a place to do short form stuff is super important for the profession. And I think a lot of the law professor blog networks have done an incredibly valuable service. So if you look at like the business law professors, and that's where, an individual contributor might really not have enough to sustain an audience, but you can get a critical mass. And I think that retains significance even as we seem to be shifting more towards Twitter. It's really useful to have those sort of short and medium form spaces for us to engage in.
Yeah, that makes sense. Well, Rebecca Tushnet, I really appreciate your taking the time to discuss blogging with us here today.
Thank you very much.
And listeners can find the blog at Tushnet, TUSHNET.blogspot.com. Rebecca Tushnet's 43 blog or 43B log, depending on how you want to say it. Rebecca, stay well, and I hope you're able to get back up to the Cambridge area sometime soon.
Me too.
Thanks a lot.
All right, thank you.
Bye. That does it for today's show. This is Bob Ambrogi. We will be back again next week with another episode of This Week in Blogging. Thanks for This Week in Legal Blogging. Thanks for listening.